it pleases the Court, Your Honour, my name is Mr. Crane, initial K, and I am appearing on behalf of the defendant, Mr. G. Featherstone. Your Honour, the maximum penalty for my client's offending under Section 398, subsection 1 of the Criminal Code is 5 years imprisonment. However, there are several special circumstances present, such as the fact that Mr. Featherstone was the employee of the complainant, the property stolen had a value of more than $5,000, and Mr. Featherstone has been convicted of previous stealing offences that increased the maximum penalty to 10 years imprisonment. We note that my client's offence was not violent in nature and that the gravity of the offence should be lessened because there was no malice from my client to the complainant, which was considered in the Queen and Hampshire and is stated in Section 9, subsection 2, paragraph C of the Penalties and Sentences Act, hereinafter referred to as the PSA. Now, Your Honour, in fact, my client did not even understand his actions as stealing because he intended to return the equipment once he had used them for his podcast. Now, while ignorance of the law is not an excuse, it is nevertheless instructive when determining the extent of my client's intent to cause loss to the complainant. I would also like to address my client's 6 previous convictions. 3 were for driving offences, which cannot reasonably be treated as aggravating factors under Section 9, subsection 10 of the PSA, having regard to their irrelevance to an offence of stealing. However, Your Honour, the other 3 convictions were for minor stealing offences of property under $300. Now, Your Honour, the defence admits that these should not reasonably be considered aggravating factors to the current offence, having regard to the different nature of the offences under Section 9, subsection 10, paragraph A of the PSA. The defence admits that it is a significant difference of the value of the property stolen such that they could not reasonably be considered similar in nature. Now, Your Honour, I would also like to turn to the report provided by the Queensland Corrective Services, which is mentioned in paragraph 5 of defence submissions. It states that my client has completed just over a quarter of the available hours for his community service obligations, which under sections 9, subsection 2, paragraph N, and section 121, subsection 2, should be considered in this resentencing hearing. Your Honour, I would also like to address the Crown's submission that my client should be sentenced to a period of imprisonment as a means of specific deterrence mentioned in section 9, subsection 1, paragraph C of the PSA. The defence would like to respectfully disagree with the Crown's assessment. I would like to remind the Court that under section 9, subsection 2, paragraph A of the PSA, a sentence of imprisonment should only be imposed as a last resort, and a sentence allowing the offender to stay in the community is actually preferable. Now, there are several circumstances which the defence admits the Court should have regard to, which supports our contention that imprisonment would not be appropriate in these circumstances. So, Your Honour, my client pled guilty to the offence, which under section 13, subsection 1 of the PSA, the Court must take into account and may reduce the sentence that would have been imposed had my client not pled guilty. Now, Your Honour, I would also like to direct your attention to Alley and Wilkie, which mentioned that the simple threat of imprisonment can be an effective method of specific deterrence. Your Honour, we submit that specific deterrence has in fact been effected in this case. My client has been shielded from considering the possibility of imprisonment. Now that he is actually faced with the real possibility of being sent to prison, he has been delivered a significant reality check. He is aware of the potential consequences of his actions, and I would submit that he has been sufficiently deterred to perform the purpose of specific deterrence. Your Honour, one of the factors contributing to my client's ignorance and apparent unawareness of the consequences of his actions is his relative youth. Now, it has been stated in Queen and McGaffin, often young offenders do not fully understand the nature, seriousness, or consequences of their criminality. And, Your Honour, we would submit that this is certainly the case here. My client did not appreciate the nature of taking the audio equipment from the shop. He did not even appreciate the criminality of those actions. So, Your Honour, under Section 9, subsection 2, paragraph F of the PSA, we submit that my client's relative youth should be taken into account when determining a sentence. We would also like to draw Your Honour's attention to Queen and Kinnison Smith and Connor, ex parte Attorney General, Queensland, which also states that where youthful offenders are involved, deterrence should be relegated to a purpose secondary to that of rehabilitation. Your Honour, I would actually also like to draw your attention to the actual loss caused by my client's offending under Section 9, subsection 2, paragraph E of the PSA. The complainant received the property taken by my client and was able to sell them, albeit at a reduced price. Now, though my client did take property worth $5,250, the actual loss the complainant sustained was substantially less than that. Now, Your Honour, a relevant circumstance that the court should have regard to under Section 9, subsection 2, paragraph R of the PSA is my client's continuing employment with an auto parts retailer. Now, Balshaw and the Queen has stated that being involved in gainful employment up to a sentencing, such as my client has been, should be considered a mitigating factor. Furthermore, Your Honour, in Atmore and Milner, it was stated that continuing employment is an important factor in rehabilitation. And now I have a reference from my client's current employer stating that he would continue to be employed if Your Honour did not impose a non-custodial sentence. Now, Your Honour, I would also like to draw your attention to correspondence I have received from my client's general practitioner, which states that Mr. Featherstone suffers from chronic depression, which should be taken into account by the court under Section 9, subsection 2, paragraph R of the PSA. Yarnton and the Queen, Mulhartis and the Queen, has stated that when an offender is suffering from a mental illness, the emphasis that is placed on deterrence should be lessened. It should also be considered, as it was in Queen and Adam, that imprisoning my client would simply exacerbate his condition. Now, it is with regard to the factors I have outlined that the defence submits that imprisonment would not be an appropriate sentence in the circumstances. Rather, Your Honour, the defence submits that an appropriate penalty would be to reimpose the community service order on Mr. Featherstone under sections 101 and 121, subsection 1 of the PSA. Now, Your Honour, unless there is anything further, that concludes my submissions on sentence.